One man, 50 years, zero benefits. In 2024, a federal judge forced the Department of Veterans Affairs to answer a question it had dodged since 1945. Why were black veterans being denied benefits at rates 22% higher than white veterans? The veteran who made them answer had been fighting since 1970, when the Marine Corps threw him in prison, broke him, and gave him a choice that would steal the next half-century of his life. Private Monk landed in Vietnam in 1969, assigned as a truck driver hauling troops and supplies through some of the war's most dangerous territory. Within 24 hours of his arrival, his unit was gassed. He hadn't even been issued a gas mask yet. The shelling came next. Constant, unpredictable. He lived in perpetual fear of snipers. Every convoy could be his last. Every road could hide an ambush. The young Marine from Connecticut had entered a nightmare, with no clear exit. The enemy wasn't just the Viet Cong. It was the environment itself. Agent Orange, the toxic herbicide the military sprayed to clear jungle cover, drifted through the air, settled on his skin, contaminated his water. He didn't know it then, but that chemical exposure would poison him for the rest of his life, causing diabetes and other conditions that would manifest years later. In November 1969, after months of combat operations, Monk's unit was pulled out of Vietnam and transferred to Okinawa, Japan. He should have felt relief. The shooting had stopped, but something inside him had broken. He began experiencing flashbacks. Nightmares jolted him awake, drenched in sweat. Rage erupted without warning. He couldn't sleep, couldn't relax, couldn't function. Every sound sent his nervous system into high alert. What Conley Monk Jr. was experiencing had a name, though the military wouldn't officially recognize it for another 11 years: post-traumatic stress disorder. In 1969, the psychiatric establishment called it gross stress reaction, or dismissed it entirely as weakness. The Marine Corps had no protocol for treating it, no understanding of it, no patience for it. When traumatized Marines acted out, the military's response was simple: punishment. Monk got into 2 altercations on the base in Okinawa. The details of what happened vary in different accounts, but what's certain is that his untreated PTSD drove behavior that the military classified as misconduct. He was thrown into the base prison, and there, Marine Corps officials presented him with an ultimatum that would define the next half-century of his life. Sign papers agreeing to an undesirable discharge and waive his right to a court-martial, or stay in prison indefinitely. Monk was young. He was scared. He was broken. He signed. What he didn't understand at 21 years old was that those papers weren't just ending his military service. They were ending his future. An undesirable discharge, later renamed other than honorable, is sometimes called bad paper by veterans. And bad paper is a life sentence. With that discharge status, Monk was no longer legally considered a veteran, which meant he was ineligible for veteran benefits. All of them. Disability compensation for his PTSD and Agent Orange exposure, education benefits to attend college, low-interest home loans, medical care at VA hospitals, unemployment insurance, everything. The government he'd risked his life for had declared him unworthy of the promises it had made. Monk returned to Connecticut in 1970 and tried to rebuild. He'd worked as a dishwasher at a VA hospital before enlisting. He assumed he could get that job back. He couldn't. His discharge status disqualified him from federal employment. He applied for unemployment insurance from the state of Connecticut. Denied. Because individuals with undesirable discharges weren't considered veterans, they were ineligible for the unemployment benefits extended to returning service members. "I knew this angry person wasn't me," Monk later said. "My father served in World War II, my sister was Vietnam era. They all served well, and here I come home a broken man." His father, Conley Monk Sr., had served in the army during World War II. He'd participated in the Normandy invasion in 1944, fighting in one of the most brutal campaigns in American military history. Like all black service members at the time, he'd been forced to serve in a segregated unit. During his service, Conley Sr. developed stomach problems that plagued him for decades. He applied for VA disability compensation. The VA denied him. He applied again. Denied. He spent years fighting for recognition of his service-connected medical condition. He never received it. Conley Sr. worked 2 jobs to support his family, one at Yale New Haven Hospital and another at Seamless Rubber Company. He became chairman of the Deacon Board at Thomas Chapel Church of Christ in New Haven, respected in his community despite the government's refusal to honor his sacrifice. He died in 1989, never having received the disability benefits he'd earned on the beaches of France. Watching his father's futile struggle should have discouraged Conley Jr. from fighting his own battle with the VA. Instead, it fueled him. If the system had failed his father, maybe exposing that failure could prevent it from failing others. Starting in the early 1970s, Monk began what would become a 5-decade campaign to overturn his discharge and secure his benefits. In 1971, shortly after separating from the military, he applied for unemployment insurance. Denied. In 1976, he applied for education benefits to attend college. Denied. In 1981, he applied for disability benefits for his PTSD. Denied. In 1983, he applied for a VA home loan. Denied. Every rejection cited the same reason. His discharge status made him ineligible. For years, Monk lived on the edge. He experienced homelessness. He struggled to support his family. It was hard to make ends meet, he said years later. And we Vietnam veterans are getting older. We can't wait forever. In 2010, Monk suffered a stroke. He applied again for disability benefits. Denied. In 2012, he tried again. Denied. By this point, Monk had been fighting for over 40 years. Most people would have given up. Most people would have accepted that the system was unbeatable. But Conley Monk Jr. had discovered something that the Department of Veterans Affairs hadn't counted on. He wasn't alone. In 1982, Monk had co-founded the National Veterans Council for Legal Redress, a Connecticut-based organization dedicated to helping veterans with bad paper discharges. Through NVCLR, he'd spent decades counseling other veterans, helping them navigate the bureaucracy, occasionally even talking veterans in crisis out of standoffs with police. I was a Vietnam vet, he said. I understood what they were going through. Through this work, Monk noticed a pattern. Many of the veterans he helped were black. Many had PTSD that had never been recognized or treated. Many had been given undesirable discharges for behavior that white service members walked away from with slaps on the wrist. The military discharged black service members at rates 1.5 times higher than white service members. The statistics were stark. The implications were staggering. In 2014, Monk connected with the Veterans Legal Services Clinic at Yale Law School. Together, they filed a federal lawsuit that would eventually force the Pentagon to change how it handled discharge upgrade requests for veterans with PTSD. The case was Monk v. Mabus, named after then-Secretary of the Navy Ray Mabus. The argument was straightforward. PTSD wasn't recognized as a medical diagnosis until 1980. Thousands of Vietnam veterans had been discharged for behavior directly caused by untreated combat trauma. The military's administrative boards had been denying discharge upgrade applications from these veterans on a near categorical basis, refusing to consider whether PTSD explained their conduct. The lawsuit demanded those boards apply appropriate standards when evaluating PTSD-related upgrade requests. After Monk and 4 other Vietnam veterans filed the case, Secretary of Defense Chuck Hagel issued new guidance in late 2014. The boards would now give liberal consideration to applications from veterans with PTSD. Monk reapplied to have his discharge upgraded. In 2015, after 44 years of denials, the Pentagon finally granted it. He was given a general under honorable conditions discharge. It wasn't fully honorable, but it was enough. He was now eligible for benefits. I didn't think this day would come, Monk said at a press conference. My bad discharge has been a heavy weight that I've carried every day for 45 years. This discharge upgrade means everything to me, because it says that my combat wounds have been acknowledged and my service to my country credited. The VA finally began processing his benefits applications, disability compensation for PTSD, medical care for his diabetes caused by Agent Orange exposure. The money started arriving, but Monk's mind wouldn't rest. 45 years. He'd waited 45 years for benefits he should have received in 1970. How much had that cost him? How much had it cost his family? His father had died without ever receiving his benefits. How many other black veterans had suffered the same fate? The question haunted him, and in 2020, his discharge was fully upgraded to honorable, erasing the stain entirely. But by then, Monk wasn't fighting just for himself anymore. Through NVCLR, Monk had partnered with the Black Veterans Project, an organization advancing research and advocacy to eliminate racial inequities in military and veteran systems. In 2021, they filed a Freedom of Information Act request with the Department of Veterans Affairs, demanding data on disability claims decisions broken down by race. The VA fought the request, but eventually, under legal pressure, the agency released the numbers. And those numbers confirmed what Monk and thousands of other black veterans had suspected for decades. The system was rigged. From 2001 to 2020, the VA denied disability claims filed by black veterans at an average rate of 29.5%. For white veterans, the denial rate was 24.2%. Black veterans were 21.9% more likely to have their claims denied than white veterans. Every single year from 2001 to 2020 showed a statistically significant disparity, and that was just the data the VA had released. The discrimination almost certainly stretched back further, much further, potentially all the way to 1945, when the original GI Bill was signed into law. The GI Bill, officially called the Servicemen's Readjustment Act of 1944, promised World War II veterans education benefits, home loans, and unemployment assistance. It's credited with creating the American middle class, sending millions of veterans to college and helping them buy homes. But for black veterans, the GI Bill was a cruel joke. Southern states, where most black veterans lived, administered the benefits through segregated systems designed to minimize black participation. Black veterans were steered away from four-year universities and toward vocational training. They were denied home loans in white neighborhoods through redlining. Local VA offices, staffed by white officials in Jim Crow states, routinely rejected black applications while approving white ones. Only 6% of black World War II veterans earned college degrees after the war, compared to 19% of white veterans. The wealth gap that created still echoes through black families today, and Conley Monk Jr.'s father had been one of those veterans. Denied his disability benefits, denied his piece of the promise. On November 28, 2022, Monk filed another lawsuit. This time, he wasn't suing to fix his own discharge. He was suing the entire Department of Veterans Affairs for systematic racial discrimination in benefits administration. The case was Monk versus United States. Monk filed on behalf of himself, the estate of his deceased father, and the National Veterans Council for Legal Redress. The complaint was devastating in its detail. It documented how the VA had known about racial disparities in benefits decisions since at least the 1970s, how the VA's own Advisory Committee on Minority Veterans had warned the agency repeatedly, starting in 2013, that minority veterans were receiving lower disability ratings, how a 2017 draft VA report showed significant disparities in PTSD claim grant rates between black veterans and other groups, how the VA had done nothing to fix it. The lawsuit accused VA leadership of negligence, of failing to train, supervise, monitor, and instruct agency officials to identify and correct racial disparities, of subjecting black veterans to a discriminatory system that caused dignitary emotional and psychological harm. Monk wasn't asking the court to retroactively approve his specific benefit claims. He was asking for compensation for the pain of having spent decades fighting a system that discriminated against him because of his race, for himself, for his father's estate, and potentially for a nationwide class of black veterans. The lawsuit sought $1 million in damages. The federal government's response was predictable. In early 2023, the Justice Department filed a motion to dismiss, arguing the court lacked jurisdiction to hear the case. The government claimed sovereign immunity, the legal doctrine that protects the United States from being sued without its consent. The government argued that Monk's claims were really about his benefits decisions, which federal law prohibited courts from reviewing. The hearing on the motion to dismiss took place in November 2023 at the federal courthouse in Bridgeport, Connecticut. Monk walked into the courthouse with his legal team from Yale. "This is a wonderful day," he said, "to know that we have a chance to get some sort of justice." His brother Gary Monk, a veteran himself and executive director of NVCLR, was less optimistic. "I feel there's a lot of guilt with the country with how they treated their veterans," Gary said. "And so the motion to dismiss doesn't surprise me, because they're continuing to deny us as usual." The federal judge assigned to the case was Stephen R. Underhill, a graduate of Yale Law School's class of 1984. He took the motion under advisement. For months, Monk and his legal team waited, and on Friday, March 29, 2024, Judge Underhill issued his ruling. 25 pages. The court denied the government's motion to dismiss. The case would proceed. In his opinion, Judge Underhill wrote that the VA should have known as early as the 1970s that black veterans were at a greater risk of benefits denials than white veterans. He found that Monk's allegations of systematic racial discrimination and the resulting dignitary, emotional, and psychological harm were sufficient for the case to move forward. The court determined it had jurisdiction because Monk wasn't challenging specific benefits decisions. He was challenging the negligent failure of VA leadership to address a discriminatory system they knew existed. That was a tort claim, and the Federal Tort Claims Act allowed such lawsuits to proceed. The ruling was historic. Reparations cases, lawsuits seeking compensation for historic discrimination, almost never survive motions to dismiss in federal court. The legal barriers are enormous. Sovereign immunity, statutes of limitations, standing issues. But Monk v. United States had cleared the first major hurdle. It was one of only a handful of federal reparations cases to reach this stage in American history. "I am so relieved and proud of my team," Monk said after the ruling. "It has been some 50 years of waiting for some sort of justice and resolution for how the VA system treats black veterans. This decision not only excites and inspires me, but also brings hope to other veterans who have suffered." Richard Brookshire, CEO and co-founder of the Black Veterans Project, called it the most important legal case reckoning with the legacy of racial discrimination against black veterans in our nation's history. He explained what the discrimination had cost. Since its inception, the Department of Veterans Affairs has designed and implemented its benefits programs to reinforce our nation's racial caste system, neglecting its moral, ethical, and legal responsibility to intervene to ensure racism was not a barrier to accessing home loans, education benefits, and disability compensation. The consequence has been dire, resulting in hundreds of billions in economic loss to black veterans and their families since World War II. The case is still ongoing. The government hasn't given up. In 2024, the Justice Department filed a motion asking the court to certify an interlocutory appeal, which would allow them to challenge Judge Underhill's jurisdiction ruling at the appellate level before the case proceeded further. In February 2025, Judge Underhill denied that motion too. Discovery is now underway. The VA is being forced to produce documents. Former VA officials are being deposed, including Margarita Devlin, who served in high-ranking positions in the Veterans Benefits Administration from 2017 to 2021. The legal team is piecing together how the discrimination worked, how VA employees made decisions, how supervisors failed to correct disparities, how leadership ignored warnings. If the case ultimately goes to trial and Monk wins, it could open the door for thousands of other black veterans to file claims. The Yale Veterans Legal Services Clinic has said it will help file administrative claims on behalf of veterans who believe their cases were wrongly handled. The financial implications for the government could be enormous, but the moral implications are even larger. The numbers tell a story the VA can no longer deny. The 2021 FOIA data showing 21.9% higher denial rates for black veterans from 2001 to 2020. A 2023 Government Accountability Office report analyzing VA data from 2010 to 2020 finding that Black veterans had the lowest approval rate of any racial group at 61%, compared to 75% for white veterans. The GAO analysis of specific medical conditions, finding that differences in approval rates were particularly stark between Black and white male veterans, with Black male veterans' rates being 3 to 22 percentage points lower for conditions like tinnitus and post-traumatic stress disorder. The VA's own 2017 internal emails between a veterans law judge and an attorney at the Board of Veterans' Appeals containing racist messages about Black claimants, communications referred to as a forum of hate. These aren't anecdotes, these aren't suspicions. This is documented, systematic, institutional discrimination maintained across decades by the agency responsible for serving those who served. VA Secretary Denny McDonough has acknowledged the problem. In 2023, he created an agency equity team to study grant rate differences and establish policies to ensure fair treatment. "There's no place for any disparities at VA," McDonough said. "We'll stop at nothing to make sure that we're providing all veterans, including Black veterans, with the world-class care and benefits they deserve." But acknowledgement isn't accountability. Study groups aren't reparations. Conley Monk Jr. isn't interested in promises. He's interested in justice. And at 76 years old, after more than 50 years of fighting, he's closer to it than he's ever been. This isn't just Monk's story. It's the story of his father, denied benefits after Normandy. It's the story of thousands of Black veterans from World War II who came home to Jim Crow and a GI Bill that was administered to exclude them. It's the story of Korean War veterans who served in integrated units but faced discrimination when they applied for benefits. It's the story of Vietnam veterans like Monk who came home broken and were punished for their wounds. It's the story of every Black service member who answered their country's call and then had to fight their own government for what they'd been promised. Monk's brother Gary put it simply. "My father fought on the beach at Normandy. My brother fought in Vietnam. My sister and another brother, as well as myself, served. But like generations of Black veterans, when we returned home, the VA refused to provide us with the benefits and care that our service had earned. And we will not stop fighting until VA treats all veterans equally." The case continues. The discovery process grinds forward. The government continues to resist. But Conley Monk Jr. has already won something the VA can never take away. He forced the system to admit what it spent decades denying. He made the discrimination visible, undeniable. He proved that one veteran, armed with nothing but documents and determination, could stand against the most powerful bureaucracy in America and make it answer for its sins. Whether he ultimately wins monetary damages, whether the case becomes a class action, whether it leads to systematic reform, none of that can erase what he's already accomplished. He fought for 50 years, and he's still fighting. Because some battles aren't just about winning, they're about refusing to let injustice have the last word.